You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury? Happy Freedom Friday. Thank you so much for tuning in to another episode. On today's episode, we will be having a trial breakdown where our guests will show us how, despite having challenging charges and allegations, that even in the face of dire consequences, you have to do the challenging task of taking your matter to the box, because on principle, justice needs to rise above all. And so we're going to hear how he attacked the case, what was successful for him, what challenges he overcame, and he's going to hopefully provide us all with some future successes we could have of ourselves. So joining me today is Deputy Public Defender Leo. Leo, please introduce yourself to the members of the jury.
Hello, members of the jury. My name is Leo. I've been doing this job for a couple of years, since 2016. I entered in this office and ready to talk about this uphill battle, because that's what it was.
Well, we really appreciate you giving us your time and insight into what I anticipate being a fantastic litigation experience. And so right away, why don't you just give our audience a breakdown of the charges that your client was facing in this case and what the ultimate motivation was for pushing it to trial?
Before I begin, I want to make it clear that I don't condone any sort of violence or domestic violence for either male or females. So this case was a domestic violence charge case where the DV unit had it for the prosecution's office. Client was charged with corporal injury, with GBI, which is great bodily injury, and then they ended up adding a misdemeanor battery at trial. And the significance of the strike is, well, so the felony by itself, the 273.5, is a felony, but when you add the great bodily injury allegation, it becomes a strike. So those of you may have heard of the three strikes law here in California. What that means for our clients is that if a client either pleads guilty or goes down at trial on a strike charge, that means it's stuck with them forever. They're never going to be able to get rid of it. No expungement, no reduction. It's going to follow them until they are no longer in this world. So for this client, he did not have any felonies, let alone any strikes. So the offer had always been the strike. And client came to the crossroads where he needed to decide whether he wanted to go to trial or resolve the case for a strike.
You know, I want to interrupt you right there, because that just right off of the bat, I think would fall in the category of what we, typically refer to as a grenade, especially when you compare the devastating consequences that individual was facing compared to the lack of criminal history that existed prior to the incident. And I think that's what a lot of society sometimes don't necessarily understand, is how it's not all that difficult sometimes to find yourselves in these types of situations, to go from this lifelong life of being a law-abiding citizen to one, night or day of making some bad choices. And the next thing you know, you find yourself looking at a felony, domestic violence with a great bodily injury strike offense. Like there, and on its face, us in the field know how challenging of charges those are, because you have the stigma of domestic violence, you have the stigma of the allegation just by nature of a great bodily injury, and then legally speaking, we all know, like you indicated, that's a strike and would add potentially years on a now eligible prison sentence. And so, I know that there are times where you read a set of facts and you have to just on its face say, no, this case needs to go to the box. But then there are other times where, you could potentially see yourself coming to common ground, but it has to be a benefit of the reward. And I like to be in that camp too, where, strike offenses, a lot of times, in my opinion, especially the first ones, they should be earned besides pled to. And so, kudos for you and your client for, seeing those challenging facts up front, but still being able to exercise his right. And so why don't we start getting into a little bit of the details in the case? I think, why don't you give us an overview as to what the allegations were? Let's say, what was the record the prosecution made at the arraignment for a bail's sake? What was their purview of the case?
Before I get into that, I think I forgot to mention that another consequence, as you know, our clients face is whenever they go down on a strike or they plead to a strike, the district attorney's office does not hesitate to use that against them. So that means that any case they pick up in the future, the exposure time doubles up. So that's another thing that clients have to think about. Not all of our clients come back. I like to hope that they don't come back, but when it does happen, that strike always comes back and haunts them. So it's a case-by-case basis. There are cases where the evidence is what the evidence is, but in this particular case, client wanted to be heard. His position was, I didn't do what they're saying I did. And this is going to be important when we get to eliminate motions, because client had a history in the past that was used against him in this trial. But one of the things he wanted to make clear was, I want to tell my story. I want you to tell my story. I didn't do what they said I did. So then we confirmed trial, and then we got to the trial department where we started arguing motions in limine.
What were the factual allegations that led to the prosecutor charging your client and adding the GBI allegation?
The allegations were that client was dating his current girlfriend at the time, and they went to a gathering, and on the way home from the gathering, there was an argument. Started as a just verbal argument, then it got physical. During the physical argument, the reporting party's arm was broken. The reporting party went to the ER at the hospital. She told the nurse that her boyfriend at the time had broken her arm, and that he had reached over, pulled it and twisted it, and just essentially broke her arm. The reporting party tells the same thing to the physician that was on duty at the ER. And she also tells the same thing to the police officer who took the police report. When the police officer arrived on scene, the reporting party's arm was already in a cast, and she was interviewed and essentially alleged that my client at the time had broken her arm.
Was she specific with the details as to how he did it, or just kind of somehow implicating him?
She was as specific as she could be. She said his name, gave the address where he was living, and as far as how the arm broke, the only thing that comes to my mind was she just essentially said he reached out, pulled and twisted the arm, and that's how it broke. And that's what she said to the police, to the nurse, and to the doctor that treated her.
And so then, is it a fair thing to say then, going into this trial, what you have is a he said, she said type of case?
Right. Except one of them has a broken arm. So that was, when I first got the case, I was like, man, a broken bone, right? So let's see. We'll take it step by step, right? Because anybody can objectively just say like, oh man, broken arm. She didn't break her own arm, right? The person didn't break their own arm. So that was a discussion I had to have too. And it was a challenge, but again, I took my time step by step, talked to client, we discussed it, and we took the position that this is something that needed to be heard by the jury.
And that's always very, very respectable. I wanted to go ahead and you had alluded to there being a contested hearing in the motions in limine during some of your clients' prior convictions and I'm assuming the prosecution's desire to bring them in. Tell us about the arguments and ultimately what the ruling was.
So one of the motions in limine that was argued, and this is actually, I always personally think that you just never know what's going to happen at trial, right? Trial is fluid. Things change. You need to be able to adapt. You need to be able to keep attacking the hill. Sometimes things don't go your way. Sometimes things do go your way, but at the end of the day, you have to be ready for anything. So one of the motions that we actually litigated was whether or not the reporting party could give her personal opinion as to what her diagnosis was at the hospital. But it turned out that based on one of the prosecution's motions in limine, I actually had to withdraw that motion. So that was something that I had to think and strategically also request for it to be withdrawn, because the way I saw the case, it was more beneficial for the reporting party to talk about that in this case so that I would be able to cross-examine her on that. Because if the motion was granted from the defense, then she wasn't going to be able to talk about her diagnosis and what she believed was her injury. So then at the time, it was requested by the prosecution. So I said, okay, well, at this time, we're withdrawing that motion. The next motion that I think was very, very detrimental to the defense was the decision that was made by the court of allowing 14-year-old convictions to come into trial. So not only were they 14 years old, the evidence code itself states that if the conviction is over 10 years old, then it presumptively is to be excluded unless the court finds it in the interest of justice to allow it in. I have a hard time digesting how it's in the best interest of justice when you have somebody being charged with these charges and allegations to allow in not only misdemeanor convictions, but 14-year-old misdemeanor convictions that came in.
Were they what were they similar charges? Is that what the basis was?
Yeah, so under evidence code 1109, the prosecution moved to admit prior domestic violence convictions, and one of them was just, it can be prior conduct too. So they don't need to be convictions. It can be just prior conduct. If there's an issue with your client and someone else, and there was no arrest or there was a police report written, but there were charges never filed, that's also used to essentially bring it into trial. And the evidence code says that the jury is instructed not to use it as propensity evidence. But we all know on the defense side that you can hope that they don't use it as propensity evidence, but that the jury is gonna think that.
Yeah, like I've always struggled with that evidence code as well, because in the evidence code, it talks about how in other areas of the evidence code, in the 1100 sections, it talks about character evidence and how you're one is supposed to be prohibited from admitting evidence in the style basically to then argue, well, he did it before, so he did it again. And this 1109 allows them to admit it under a different pretext, but it ultimately ends up being that argument. And so it is definitely a detrimental evidence code that is used against clients frequently, specifically in domestic violence cases. And so, sometimes judges rule in our favor, other times they don't. That does sound like a bad blow for those to come in, especially given the context of being 14-year-old misdemeanors. Sounds a little bit of 352 to me, but, we don't wear the robes. We just have to deal with the punches. So, getting that ruling, was that the last of the motions in limine, or were there any other major points of contention?
Those were the main major points of contention for this case. And you're right. At the end of the day, we don't make the call, but as you and I know, that there's several 1100 evidence codes that allow prior conduct. There's 1108 for sex crimes, and then I've had cases where client has prior thefts and they come in, and how are you going to tell the jury this person has been convicted of stealing stuff before and now he's here for a theft case, but disregard that. Don't use it for propensity. So it was one of those situations, right? In this particular case, not only was not only were the 14-year-old convictions allowed in, the actual reporting party for those cases came in and testified in front of the jury and cried. So you can imagine how prejudicial that was. Me and my client are sitting there. Here comes this person from 14 years ago, kind of like a blast from the past, right, for client. And there's a reporting party just sobbing.
Leo, I have to give it to you because if I didn't already know what was potentially coming as a result, I would be baffled. I mean, add that on top of already the brutal nature of the complaint with the GBI and the strike, and this sounds like very challenging. A case to get through. So let's find out exactly how you were able to accomplish such a fantastic feat. Why don't you take us into the opening statements? Give us a little breakdown as to what the prosecutor alluded to the jury in their opening statement as to how they thought the case was going to go, and ultimately how you responded in your opening statement.
So opening statement. So I will say the prosecutor assigned to this case, I've had cases with her before, tried misdemeanors when we were coming up. And she's a good trial attorney. She knows what she's doing, and that's why when she asked the judge to bring in the 1109, I wasn't surprised because she's one of those prosecutors that crosses her T's and does everything she needs to do to get her uh, job done. So she basically stated what she had on the police reports, that the reporting party had an altercation with my client, and during that physical altercation, client broke her arm, and that she immediately went to the ER, was treated, and that she told not one but two other people, the police officer and the doctor, that client had broken her arm. And she talked about her doctor that was going to come in and tell them what type of break it was and how it's possible for somebody to physically break another person's arm. And she focused on that a little bit and just basically saying this is what the reporting party said and this is what happened. So my opening statement was more of, I'm not disputing that the arm was broken, but we need to slow down, be very open, and pay attention to what happened and why or how this arm was broken. And essentially told the jury that at the end of this trial, they were going to know that my client was not the one that broke the arm. And I didn't really say anything more than that because I didn't know what was going to be testified to by the doctor or by the nurse, and the reporting party was going to take the stand. And after opening statements, we got into the prosecution's case in chief.
Yeah, no, I think that's always a valid strategy. You never want to overpromise in an opening, and especially in these type of cases, you could be dealing with a recanting victim or just testimony never coming out the way that that you thought it was. And so I always like to take that more of reserved approach to opening too. So take us into the prosecution's case in chief. Where did you find them spending a bulk amount of their time? Was it with, law enforcement and hospital personnel? Did they spend a pretty decent amount of time with the complaining victim? Give us some insight.
They spent a lot of time with the reporting party and just essentially had her retell her story and how it happened. And there was a point during the case in chief where the reporting party suddenly flipped on the prosecution. She started talking about how she was not truthful on the day of the incident. And at that point, the prosecution spent most of her time pinpointing the fact that she stated that client broke her arm on the day of the incident. So once that was done, I didn't really see the prosecutor fighting her too much on the contradictory things or on the recanting. And I think it was strategy also because, if I'm the prosecutor at the end of the day, I'm going to say, She said this is what happened on the day of the incident. Time has gone by. Maybe she changed her mind. Maybe she talked to other people.
Did you find that the prosecutor, was there a battle between whether or not the prosecutor was impeaching her versus like refreshing her recollection? Because I always think that that's an interesting dynamic that sometimes the prosecutors have to take when a witness testifies differently than what they had previously reported. Because once a witness live is impeached, the opposing party is immediately going to be able to attack a layer of the credibility.
Right. So the prosecution didn't spend a lot of time on impeaching her because this reporting party was truthful in the sense that when she was asked, "Isn't this what you told the police on such and such date?" She would say, "Yes, that's what I told them." So there wasn't any need for her to be impeached or her recollection to be refreshed. But at the same time, she was taking the position that she wasn't completely truthful on the day of the incident as to how her arm was broken.
Did she elaborate how then what was the truth?
Yeah, she basically stated that during the physical altercation, somehow her arm was broken, but she didn't really know how. That she just heard a snap and it just happened. And that's what she wanted to do to tell the jury, and she didn't really go a lot more into detail. And the prosecutor left it at that and then called the doctor, the treating physician.
Well, before I move on to the doctor, was there any clarification either by you or the prosecutor as to whether or not she was still putting blame on client?
So during my cross examination, it was what we call a soft cross examination because at this point I understood that she was no longer. I can't speak for her, but I'm assuming that on the day of the incident she was really angry because she just had a verbal and physical altercation with the client. I did ask her that on cross. She did say she was upset. She was angry on the day of the incident. So at this point, I wasn't going to get what I needed from that witness if I came in hot or came in hard. So I just talked to her as a normal person and asked her questions. Why did you tell that to the police on this day? And she told us because she was mad. This turned out to be what she told us was that it was a argument that started from jealousy and her interpretation of client being too flirtatious with people at this gathering that they had. So her explanation was essentially during cross that she was not truthful with the police or anyone on the day of the incident because she thought that Klein was cheating. Klein was too flirtatious. She got jealous. She got mad. And the verbal altercation started with words and then it got physical. And during the physical altercation, there was a struggle between Klein and her of Klein's phone. And essentially, the testimony that was given was that the phone fell between. So this happened in a car, in a vehicle. You know how there's a center console between the passenger and the driver's seat? The testimony was that the phone that belonged to my client fell in between the center console of the vehicle. During that physical struggle for the phone, reporting party stated she heard a snap. Doesn't know how. That's what her testimony was. It's just the way her arm was positioned, the way that it happened. She stated it happened way too fast for her to even realize what had just happened, other than she felt pain and her arm was broken.
Okay, that leads me to two questions. One, did it come out as to who was driving and who was in the passenger seat?
Yes. So this on the way home, this was according to what the reporting party was telling us. This was on the way home. They pulled over at the freeway. She was driving. Client was a passenger, and client didn't want to give up his phone because it's his phone, right? It's his property. And the struggle happened, and they were pulled over on the side of the road when this happened. And then that's when the arm broke.
Okay. Yeah, because I was curious because I was thinking, well, yeah, one of the things you could potentially argue if he was the driver, then when we get into the medical stuff, I'm assuming that, you're not going to be able to break a hand with a twist with one arm. I would think you would need two arms for that. And then the likelihood of him doing that while driving, I think, would be diminished. So that at least adds up that he was, at least with the allegation, that he was in the passenger seat. So sounds like reporting party is favorable to us, and I would imagine that then that's going to neutralize some of the police testimony, because the police are just going to testify as to what she told them that night, but now we have a kind of explanation as to why that would be contradictory. What about with the medical personnel? How was the kind of walk back in her testimony? How were you able to use that with your cross-examination of the medical? And what was the prosecution focusing on with the medical after the witness recanted like that too?
So at this point, I think that the position the prosecution took was they were going to hammer on the fact that she said what she said on the day of the incident. So this is what happened. So the police officer was called along with the nurse, along with the doctor, and they all testified to what was in the police reports. So I think it was more of like, as a prosecution, you have over 3 witnesses that were told the same story. Therefore, that's what happened. The client broke the arm. I think that's what the thought process was at the time. So we get to the doctor, and the doctor talks about the arm being broken between the elbow, right above the elbow is where the break was. And the doctor essentially stated that it was possible for someone to break the arm, right? But again, I'm with you with the whole, like, it takes a lot of strength, a lot of pressure for a lot of force to break someone's arm just by pulling it and twisting it. Especially if you're talking about someone that's sitting in a passenger seat in a vehicle, you're not even facing the person fully. You're giving them your side. So then that gets you thinking, like, how is this possible, right? So once the doctor testified to the fact that it's possible for someone to break the arm, given the hypothetical that he was given, right, which is essentially two individuals sitting in a car, one's in the driver's seat, one's in the passenger side. I get up on cross, and my goal was to get him to agree that it's possible for someone to break their arm a different way, not necessarily just by grabbing an arm, twisting and pulling it. And it came to the point where the doctor was just not really participating with the defense. I would ask simple questions, and he would fight me on it or give me long-winded answers. And a friend of mine was watching this, and then at that point, I decided it got a little too confusing. So it goes back to, sometimes things happen in trial where you just need to adapt and keep attacking that hill. So at this point, I realized, you know what, this doctor's not going to give me what I want with this approach that I'm taking, the nice civil right approach. I didn't get mean or anything, but what I did is I decided at that point I needed to take the jury and the doctor to the scene of the incident. So that's exactly what I did. I grabbed 2 chairs of, how sometimes you have extra chairs in the jury box? I grabbed 2 of those chairs, set it up as if it was the inside of a vehicle. I grabbed my briefcase, one of those little roller bags where all the trial stuff goes. I set that in between both chairs, and that was my center console. So I set the chairs facing the doctor on the stand, 2 chairs with my briefcase in the middle. And I told him, doctor, let's talk about what happened here, right? I'm sitting in the driver's seat. This is the driver's seat, okay? He said, okay. And I said, this is the passenger seat of the vehicle, right? It's like, you understand? Yeah. And let's say that this briefcase is the center console. And he said, okay. So he was following, right? So I said, essentially took him and the jury to the scene, and I asked him, important thing that I've learned while doing this is sometimes you just have to slow down, right? So that's what I did. I slowed down. I asked him questions. I waited for him to answer. And I told him, okay, now let's say that my arm is stuck in between the center console and the driver's seat, and it's at this specific angle. So at this point, I had my arm hyperextended, kind of like an arm bar at an MMA. You see in MMA, UFC, the arm bar move that they do. They hyperextend the arm, and then if you put enough pressure, it's gonna break, right? So I put my hand at an angle, and essentially I asked them if my arm is angled at this position, and there's force applied from the top to the bottom, is it possible that it can break? And the doctor said, yeah, it's possible. At that point, I knew that our theory of the case was supported by the prosecution's doctor. So I said, thank you, doctor. No further questions. And I undid my vehicle setup I had.
Ooh, that sounds very well executed, Leo. And I mean, me just sitting here on the other side of this conversation, I felt like I was taken to the inside of a car. And for me, because I think I have that trial experience too, I actually was taken to the scene of your cross-examination and have you envision taking them to the scene. And so I find that as well very, very persuasive and influential. And I would have to imagine your jury did too, especially when I can imagine there's very little visuals that the prosecution have utilized at this time, especially when in a he said, she said, that the testimony tends to be their more powerful types of evidence. And so to be able to counter that with a counterproductive alternative theory as to how that could potentially happen, I think is huge, especially because, from what I'm deducting from what was testified to, because she now was backtracking, you're going to be able to take advantage of 224, which is that reasonable alternative circumstantial evidence mandate that says for juries to vote not guilty. And you have now the doctor agreeing with you that is a reasonable alternative because it was possible for the arm to get stuck in there. And even if client did apply the force to break it, if that wasn't his intent and it was accidental just because of the commotion, then that can't necessarily be responsible for the GBI. So I think that was fantastic. Was there any other type of really impactful moment that you can recall that happened during your cross-examination that really illuminated how you were going to argue your closing in this case?
That was probably the pivotal moment for the defense in this jury trial, because at that point, how sometimes we tend to ask one too many questions, or sometimes we're like, man, I shouldn't have asked that, or maybe I would have been better off not asking that. So at this point, that was my sit down point for the doctor. But based on his testimony, I now knew that I had nothing to ask that would be of value to the jury from the nurse. So when the nurse took the stand, the prosecution did their direct examination. Essentially, it was what was said on the police report. And I got up, grabbed my yellow pad, buttoned my jacket. I asked the nurse, "Oh, Miss Nurse, how are you today?" She's like, "Good." She seemed a little nervous, so I took the time to like, "Is this your first time testifying?" She's like, "Yeah." I'm like, "Okay." My next question was, "Have a good day." And she seemed super surprised, like, what? Like, you're not going to ask me any questions? She didn't say that, right? But I could tell how she was surprised. And the reason for that is because there was no value in asking her any questions, because her testimony was not going to change from what she told the police officer.
And her opinion isn't going to trump that of the doctor that you just had on the stand.
Right. The doctor was the one that put the cast on the reporting party. And then I also, there's times where jurors appreciate you not wasting their time. There wasn't going to be anything coming out of the nurse that was valuable. So that was my way of showing the jury too that I respect their time, and we're here to get to the facts and of what really happened on the day of the incident. One thing that I'm glad you said earlier was the word accident. So because of that, we were able to request, and surprisingly, I say surprisingly, based on the 14-year-old conviction that came in, we were able to request Cochran 3404, the accident instruction. And that was also super important when it came to closing arguments.
Yeah, well, I want to get into jury instructions here in a minute, but What I wanted to pick your brain about was that challenging decision of whether or not to actually cross-examine a witness. Because I've been there too, where you want to be conscious of the jury's time. You don't want to beat a dead horse and ask them the same type of questions. But it's always a really tough decision for me. I mean, was it a tough decision for you here, or because you felt that without necessary, in playing into the hierarchy of the medical profession, because you essentially had the doctor's favorable testimony, at the end of the day, there wasn't just going to be anything beneficial that they could provide you?
No, for this particular witness, it wasn't difficult. It was just one of those things where we have what we need for what we believe happened on the day of the incident. So it's time to get on to the next witness.
Okay, so you've gone into how the prosecution went through their witnesses and you were able to combat them during your cross-examinations. Was there any other aspect about the trial that you would say was important before we get into the closings, with any type of media played or exhibits created that you thought maybe had an impact?
I think that the blown up X-ray picture of the broken arm was impactful, and it was helpful for the prosecution. You're showing 12 people a broken arm, and you're essentially asking them to look at this and just not pretend it didn't happen, but it's really hard after you see that X-ray of the snapped arm for a defense attorney to ask them to find your client not guilty, or just based on that, because you start to think someone's arm was broken here, right? But at the same time, if the client didn't break her arm, which is what the case was in this particular case, then you don't have a problem. Just kind of keep attacking the hill and arguing for your client, advocating for him.
Your reporting party didn't come to trial in a cast, did she?
You know what? She actually did.
Wow, really?
She was testifying. She still had her cast on.
I didn't think the trial would happen that quickly.
Right. So I was hoping that the cast would be off, to be honest with you, but it was not off. She still had a cast on. She testified with the cast on.
Was it like obvious that she had it on? Did she try to hide it, or was it like a bright neon color that like clearly stood out?
Oh no, it was a solid white cast starting from where her shoulder all the way down to,
full,
it was
full arm
the break
johns.
was above the elbow. Right, because the break was right above the elbow. So I think that's what they needed to do at the time.
There's no being discreet with those. What another layer of difficult, just that little baby hurdle to overcome. When you with the picture coupled with the cast. Wow. Okay. So we're at closings, right? Take us into the prosecutor's closing. How do were there any changes that she made from her opening to her closings? Any of those kind of big events that she addressed in her closing as she made her argument to the jury?
So her closing was sticking to the facts and how the facts and the evidence met all the elements. But I forgot to answer your question earlier when you asked me if there was anything that was challenging to decide in the trial before closings. So the client had to make the decision whether or not he was going to testify. So it's always a challenge for defense attorneys to advise their client on whether or not to take the stand. So that was also, because you always ask yourself as a defense attorney, if the outcome would have been different had the client testified or not testified. So sometimes, I've had discussions with other defense attorneys who, the outcome was not what they wanted. And, how we sometimes fixate on anything, right? So it's challenging, because once you advise your client to do either or, it's going to come with positive or not so positive outcomes.
Yeah, and that's very insightful, and I really appreciate that insight, because that is definitely always a challenging component of a trial, because it can really make or break the outcome, especially when the trial is really a he said, she said, and the jury at this point in time is only getting one side of those. So I totally get that, and fortunately, it sounds like you guys all made the right call. And so taking that into consideration, the lack of his testimony and really the lack of a defense case in chief at all, what was the prosecution really just reiterated the opening, or how was she able to overcome some of the challenges that arose during the trial?
The prosecution focused on what was presented, the picture of the broken arm, the doctor's testimony of how he testified that it's possible for an arm to be broken by another individual by pulling it or twisting it at a certain angle. And also on the reporting party's initial statements on the day of the incident, and how essentially now she's recanting because she cares about the client. So she's essentially saying that she lied for the benefit of the client.
Did she utilize the picture of the broken arm again in her closing?
Yes, it was. I remember it was put up, and then she argued everything that essentially she said in opening statements, and then we needed to close, so we went after him.
Yeah, well, and that's a little bit to be expected, especially in the he said she said type of case. I mean, what else is there really to deliberate and argue about from their point of view? They don't have the ability to really argue what you do, which is this reasonable alternative argument space, especially when you're dealing with circumstantial evidence. And I think for me, as I'm reflecting on the case that you've described, I really think that lack of testimony from the reporting party of that definitely, or very confidently saying, going from very confidently saying client broke her arm to I'm not really sure the cause, it was huge, because that takes the jury instructions that will be given from dealing with direct type of evidence to circumstantial, and I think that allows you to, from what I've heard, be really equipped to making a nice, concise, linear argument as it relates to that jury instruction 224. So let's get into it. Now we've heard how you thought there were really key takeaways that maybe in the moment didn't make a lot of sense as to what you would be arguing, but now in closing, when you have the time to bring all those little pieces together, what is it that you're arguing to the jury and asking for them to bring back an acquittal?
So essentially, now that we were equipped with not only Calcrim 224, we also had Calcrim 3404 to argue. We focus on how there's no way that client broke the reporting party's arm, because if you stop and think about it, it's unimaginable for someone in that situation, sitting in a passenger seat, giving his side to a person, even if the client turns to the person, how are they going to break someone's arm right above the elbow just with their strength, right? So one of the things that I pointed out is like there was no evidence that client was any sort of MMA fighter or had any experience in anything like that, right? Like maybe if he did, then maybe it would be believable that he had the capability to breaking the arm. But we focus mainly on the fact that the doctor told us that based on the scenario that I set up for the doctor, he said it was possible for the arm to break in that situation. And I think at some point the reporting party also told us that it was probably an accident. So I broke down 224 for the jury and explained to them that when it comes to two reasonable interpretations of what happened, one points to innocence, one points to guilt. It's not us telling you, it's the law that tells you you need to find the person not guilty. And I really hammered on that. And also on how Calcrim 3404 says that, if the person acted without the intent, the required intent of the crimes, and you find that it was an accident and it's not guilty, is what the law says. So I think that even though I had these things to argue with juries, you just never know, right? So we put our best foot forward and we argued as much as we can and connected the dots, and and hope that the jury would see what really happened on that day.
Well, it sounds like you were in a way better position than you were when we first started. I mean, obviously, you at that time we were talking about how the facts weren't on our side, the evidence wasn't on our side, the evidence code wasn't on our side, and through great lawyering, hard fought litigation, immense preparation work, you find yourself in the closing argument being able to argue some favorable facts, argue some favorable evidence, and have jury instructions that are favorable to you and the outcome for your client. And so I what a turnaround that we have found ourselves in. And so that just deserves the utmost kudos to you. How long did the jury end up deliberating?
I think it was for approximately 2 hours or an hour and a half.
Oh, so a rather quick one. What were your initial thoughts about that when you got the phone call that there was a verdict?
I didn't know what to expect, but I didn't know what to expect, and I was just hoping that the jury would follow the law and understand that because of what we argued, that the only just verdict here would be a not guilty verdict. But I couldn't say. I was going to wait until the verdict was read. And one thing I forgot to mention is that sometimes there are cases where you shouldn't run from the negative things. So remember the 14-year-old convictions that came in,
Yeah.
and the fact that the reporting party from those cases testified and cried in front of the jury. So in closing arguments, I had to address that. Right. Every case is different, but in this specific case, I felt that I needed to address that and not hide from it or run away from it. So essentially, I explained to the jury that the fact that 14-year-old incidents were being brought in said a lot to whether or not this current case was strong standing on itself, and that we all, as human beings, are not the same person that we were 10, 15 years ago. And that client, even though he didn't testify, I advocated and told the jury, this is not the same man that he was 14 years ago. It's just not possible because we are all not the same person that we were a couple years ago, right? And I was hoping that would resonate with the jurors so that somehow they would come to the conclusion that whatever happened 14 years ago, that was separate and apart from this case, and that they would focus on the facts and the evidence on this case. So when we got the verdict, client immediately started crying and reached and hugged me. And the reporting party was sitting in the courtroom when the verdict came, and she started crying also.
I want to say I really, 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 really love the piece of advice that you gave about not running away from bad facts and addressing them and even potentially spinning them into your favor. And what an example that you then provided as far as using them in this case and asking the jury to consider that actually when evaluating the case instead of what the prosecutor was asking them to use it for in evaluations. And so what a flip. Just so that we have it for our record, what was the verdict that the jury ultimately returned?
So the people of the state of California decided that client was not guilty of the strike charge, corporal injury with great bodily injury, and not guilty of the misdemeanor battery on a spouse.
Let's go, baby. Full acquittal. Congratulations, Leo. What a fantastic and justly deserved verdict. That was some brilliant lawyering. I know I definitely took away some piece of trial nuggets and advice that I think that I will definitely be able to implement in a further case of mine, and really, really appreciate you providing us that insight and for being our guest today. Before we let you go, we have to subject you to the same question we ask all of our guests here to end our podcast, and that is, what is the significance of taking matters to the box mean to you?
Well, first, I want to thank you for having me on here, and I appreciate the invitation. And the significance for me for taking cases to the box is that as defense attorneys, sometimes we get the rap that we are here to help people get away with crimes or that we're helping people get off, right? But for me, it's a place that I call the arena. And I call it the arena because you go in there and essentially most of the time you're there to tell your client's story. I'm there to advocate for my client. I'm there to tell the client's story. I'm there to make sure that everyone does their job the right, the just and fair way. And that's what it means for me to take it to the box, because at the end of the day, the community decides whether someone is guilty or not guilty of the charges that are brought against them. And a lot of times people can't speak for themselves, they can't fight for themselves. So I take it, I take it to heart that we're there as defense attorneys to fight on behalf of our clients. And like personally, I still think that I'm still fighting to uphold the Constitution of the United States. As a former Marine, I took an oath for that, and then I took another oath to uphold the constitutional rights of clients and everyone here, and that falls within the taking to the box arena.
Well, Leo, you are one hell of a trial warrior. I know you were one hell of a Marine, and thank you so much again for your service. And you're one hell of a mentor. Thank you so much again for allowing us to pick your brain, giving us this insights, and congratulations to you and your client. We wish you nothing but success on your future endeavors. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.